Ladies and gentlemen, hello and welcome to the BUL International Law Group event for this coming academic year. This event that focuses on the junction between international law and international relations, more particularly the field of defense and security when it comes to the international relations scheme. I'm Dr. Solon Solomon, co-director of the BUL International Law Group, and together with us today, we have a distinguished panel to discuss the transatlantic dialogue on defense issues. The event is co-chaired with Dr. Steven Wagner from Brunel University London also, and our first speaker will be Professor Skordas. Professor Skordas, who in essence a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law. And before that, he was a professor of international law at the University of Bristol, at the University of Copenhagen, and also in Athens, the University of Athens. Apart from this, Professor Skordas has also a distinguished parliamentary career in the legal sphere as a parliamentary advisor to the Greek Parliament on international affairs. He has written a number of books. One of his most recent works is an edited volume together with Dr. Lisa Mardikian from Brunel University London on the International Court of Justice. Along these lines, we welcome Professor Skordas. The event will be waged on the following premises. The speakers will speak about 12 to 15 minutes, and the presentations are going to be followed by brief comments and a brief discussion between also the other speakers for around 5 minutes. The floor is then going to open to you, to the audience, for the Q&A section, where you can pose the relevant questions already from now in the Q&A button that you see here in the Zoom room or in the chat. With no further delays, thank you, Professor Skordas, for being with us, and the microphone is yours.
Thank you very much, Dr. Solomon. Thank you very much, Dr. Wagner, and I would like to thank my fellow discussants. We are going to discuss a topic which has many aspects. I would like to concentrate on a question which I call the battle for global order. The war in Ukraine is the expression of a broader battle on the features of and the character of the global order and of international law as such. I will proceed in 4 steps. My first step would be the concept of a hegemonic war and of the greater space, as I use the term Grossraum from Carl Schmitt for that purpose. The second is about the causes of the war, what caused practically this war. The third is the purposes of the war, and I will conclude with what I understand as the battle of for global order. Now, something like 11 days ago, Josep Borrell, the EU High Representative for Foreign Affairs and Security Policy, made an important statement before the Diplomatic Academy in Brussels, the European Diplomatic Academy, and this statement did not get the attention it deserved. So I cite Josep Borrell, and any nuclear attack against Ukraine will create an answer, not a nuclear answer, but such a powerful answer from the military side that the Russian army will be annihilated. It's a fascinating statement. And it shows the intensity of the conflict. I don't want to take it as revealing the Western strategy of what is going to happen, but as evidence of the dimensions of this conflict. And here I would like to use the terminology of Robert Gilpin from 1981, who has spoken of hegemonic wars. So the war against Ukraine is perhaps, it's a matter of discussion, but it's perhaps the first real hegemonic war of the post-Cold War era. There were other wars, we call them hegemonic in different senses, but this is a real one. And it's a war between what Gilpin considered to be the rising and the declining powers. They reach a point in which war offers the way forward and it changes the global order. Now, of course, here, the categories are a bit different. Russia, in my opinion, is a declining power, and I will explain why. The United States and Europe are not rising in that sense. They are in a geopolitical stasis, I would say, but still they are more powerful than we assume, or the public discussion might assume. And of course, China plays also a role as a rising power, which is not directly involved in the war, but it has positions common with Russia that play an important role in this battle for the global order. Now, the West, what is the West? The West is the hegemonic war, rather, is not simply a war between two states, between two powers. It is a war involving two spaces, two geopolitical spaces. And here we have, on the one hand, what is called the West, with the United States and the European Union as core regions, but still it is a global geopolitical space with economic, military, and other activities all over the world, whilst Russia is the core power of a regional geopolitical space. I think President Obama was right in 2014 when he spoke about Russia as a regional power. The geopolitical space of Russia is the space of the former Soviet Union, which Russia attempts to bring back to life in a way, but it lacks something that the Soviet Union had, and the Soviet Union had a universalist ideology, it had a global presence, and it had a mission. Russia nowadays lacks universalism. It has a historical particularism in its foreign policy. It tries with difficulty to control that space, and it is perhaps for the first time since centuries that the Russian people lacks a purpose. During the Romanovs, Russia was or attempted to be the third Rome of Eastern Christianity. During the Bolshevik time, it was the center of a global communist movement. Now Russia is what? What is the features now of this space of the Russian Grossraum are that there is a core which is the so-called, the core for the Russians is not just Russia, it's the triune nation. It's Russia, Belarus, and Ukraine. And the war on Ukraine is an effort to integrate into Russia what it belongs to it. And I think the model for the Russians would be something like the result of their intervention in Georgia, where they succeeded to get a government which is not unfriendly to them without much effort. But Ukraine is different. Now, this state, in the 20 teens, this space seemed to be successfully constructed. Russia was able to create the internal agreements binding these states together, the Eurasian Economic Union and the Collective Security Treaty Organization. Even though not all states of the Russian sphere are members, still there are mechanisms through these two agreements that bind them together in practice. And they have an enhanced cooperation with the Shanghai cooperation organization, bringing also China into the system indirectly. Now, how does Russia exercise control in this space? There are through many ways, but I would like to focus just to refer to two. First, through the energy economy and the maintenance of the old energy networks of the Soviet Union, thus blocking of reforms and permitting them as far as it is necessary for a cooperation eventually with China. And the second, through Russian control over the security apparatus in the Central Asian republics and some other states. Now, let me come to the second step of my reasoning. The causes of the war. The causes of the war were due, in my understanding, and I may be wrong, but that's why we're here to discuss. It was the weaknesses of the Großraum. At the end of the 20 teens, a strong crisis has engulfed the Russian space, and we just need to look 2 years before the invasion in Ukraine. We had the democratic revolution in Belarus. We had the war between Armenia and Azerbaijan on Nagorno-Karabakh. We had the recurrent clashes between Kyrgyzstan and Tajikistan, and we had the violent insurgency in Kazakhstan. So even though Russia was able to stay at the top of these developments, that was a problem for it. It realized that the ground was shaking. And then it's the second big problem in the medium and long term for Russia. It's Russia has a fossil economy. Any leader of Russia can see that in the perspective of the next 20 or 30 years, despite the prosperity that this economy has brought to Russia, there is somehow an impasse. And this decline can only be stopped for the Russian thinking by proactive action, proactive military action. And what form does this action have? Now I come to the third point, purposes of the war. The purposes of the war have been indeed unprecedented in their ambition. They ended up, the Russians have somehow also, it was not the only reason, but they were also misled by the withdrawal of the United States from Afghanistan, considering that there is a post-Vietnam moment, which was wrong because the United States did what Gilpin had said, namely withdrawal from exposed and costly strategic positions. So this is what the United States did in Afghanistan. Russia thought that it was an opportunity, perhaps, and their purposes were included in 2 draft treaties that they submitted on the 17th of December 2021. The treaty between the United States of America and the Russian Federation on security guarantees, and an agreement on measures to ensure the security of the Russian Federation and member states of the North Atlantic Treaty Organization. These 2 draft agreements were not, in my assessment, propagandistic tricks. They were meant seriously. They're still on the website of the Russian Ministry of Foreign Affairs, and what they actually said was, we need to come back to the geopolitical state of affairs in 1997, before the Eastern European states had acceded to NATO. So it's a massive return back to history that they are imagining as the ultimate purpose, as the end of the road, and the war in Ukraine would be a first step. We can discuss about the content of these draft agreements, which are really impressive, but I wanted to proceed to the final step, which is that the battle for the global order is the battle for an alternative rules-based order, as we call it in the West, or authoritarian global governance, as Russians and the Chinese are saying it. And the rules-based order concept is an entrenched concept now in Western statements and the understanding of international law. It's international law as it has been developed through the practice of institutions, of NGOs, of governments over decades. For Russia and China, international law needs to be changed internally, slowly, or suddenly, depending on the circumstances. And their positions are very radical. There are at least 3 Russian-Chinese statements showing the new world order, the authoritarian world order. One is the statement of 2016 on international law. The second is a statement of 2021 on global governance. And the third is a statement of February the 4th, 2022, just 3 weeks before the war in Ukraine, on international relations entering a new era and the global sustainable development. So these are the long phrases that the Chinese are loving. But in the essence, it is about going beyond the institutions in a new system where human rights, democracy, or the United Nations play a minimal role as somehow offering avenues for China, Russia, and perhaps some other great powers to implement their decisions. So it is here not. There are also principles like the principle of the community, the principle of common destiny of mankind, which has been integrated in the 2016 statement of Russia and China. So we are in a moment in which, by international practice and by the use of force, it is attempted to change the character of international law radically. This is why the current conflict is so dangerous and so important for Ukraine to win. And this is also the reason why the United Nations use the term aggression for the Ukrainian conflict, which is an extremely improbable word to use in resolutions of the Security Council or of the General Assembly after the end of the Cold War, because it means much. Aggression is a very, very big word. It involves a major moment for the global order. Still, it was used here by the General Assembly because the Security Council does not work for the time being, as we know. And that was my argument, actually, that it's not a war on Donbass, it's not even a war about Ukraine, it's a war about the deeper meaning and the content of global order. Thank you for your patience.
Professor Skordas, thank you very much. We're going to open now, of course, the floors. We look forward to hearing the insights of Professors Hathaway and Mr. Anderson, of course, of Dr. Wagner. If the rest of the panel permits me, just a small question, let's say to open to an appetizer. We speak about the junction between international and international relations. My question is about Russia and the UN Security Council, meaning you spoke about the collision between 2 different models, the rules model and the authoritarian model. And at the same time, as Russia is trying to change international law, Russia is sitting in the UN Security Council as a permanent member and blocks any potential change or any potential condemnation. How problematic is the permanent sitting of Russia in the UN Security Council? And if you think that the current crisis will lead to a revision of the permanent membership in the UN Security Council scheme?
Yes, thank you, Dr. Solomon. This is a great question, and there is an ongoing discussion on the presence of Russia in the Security Council. And let's think also that in a few years there will be a new election when the tenure of the current Russian judge in the International Court of Justice will have to be renewed or not, and the question is what it is to be done. Here, although I find that Russia's blocking of the Security Council is highly problematic, I am very, very skeptical on whether we should engage in the discussion on forcing Russia out of it, because as we say, you keep your friends close and your enemies closer. It is necessary to have Russia in international institutions because we can see how they react. They have a forum that can help them go back if the moment comes. And in the court, it is necessary to have the Russian judge practically saying his dissenting opinion, writing down his dissenting opinion, but at the same time carrying the judgment, because the judgment is a collective act. So I would keep Russia, apart from the difficulties of pushing a permanent member out. I've seen some theoretical constructions going back to the conditional acceptance of Russia as a successor to the Soviet Union in 1991-92. Or of a possible change of the charter, but I think it would cause a huge tension. You can deny the credentials of the Russian Federation, for instance, or whatever else. You cannot change this charter. It's extremely complicated, the process. And I don't think the West would be on a losing place if they attempted something like that. I mean, if the Russians think that they have nothing to do anymore in the organization, then they should have the burden of, if they find it reasonable, which they shouldn't, to withdraw, to do whatever they want. But I don't think that they do it, and I don't want them to do it.
Thank you very much. Professor Hathaway, do you want to ask something? Any comment on the statement of Professor Skordas?
No, I mean, I'm happy to contribute my views on this question, but maybe I'll hold off for my presentation unless you'd like me to go ahead and do that now.
You can do now, maybe, yes.
Yeah, sure. So I agree with that basic assessment. But I think the idea of eliminating Russia from the Security Council is just simply not going to happen. And so, the only way in which that happens is if the entire United Nations collapses altogether and we start from scratch. That is the fundamental structure of the UN. It was somewhat short-sighted, though intentional. So for the book that Scott Shapiro and I wrote called The Internationalists, I did a lot of research into the creation of the Security Council and the decision to create a permanent 5 membership and to allow the Security Council to hold a veto, the permanent 5 members to hold a veto. And that was a member of serious debate and discussion. And in fact, the US and UK initially opposed it, but it was basically the price that Stalin exacted for the Soviet Union's joining the UN. And both Churchill and Roosevelt considered that absolutely essential to the United Nations creation. Creating a UN without Soviet Union was seen as utterly it would have been a horrific mistake. And so they took that as a cost of creating an institution. And the view was that though it would reduce the number of instances in which the Security Council would authorize action, it would also reduce the chances that the great powers would end up going to war directly with one another. And I do think that has largely worked. For all its warts and problems and all the various problems that we can talk about today, it has worked remarkably well. If we look at world history, we've had a remarkably peaceful run of it since the creation of the UN, despite the fact that, of course, we can all point to many brutal wars in which people have been killed. But if we look at human history, this is actually a remarkably peaceful time. But I guess that brings me to where I wanted to start my presentation, which is part of what I think we've seen in the last, since February 24th, 2022, is a kind of both a remarkable testing of the fundamental underlying principles and institutions of the international legal order, and I think a pretty remarkable response. Whether that response is going to be enough we still don't know, but it has been, I think, more than anyone expected would happen, certainly more than Putin expected when he launched this invasion, and I think has the potential to transform international law and international institutions. So the fundamental principle that has been challenged by Putin, by this war that he's waging in Ukraine, is the fundamental prohibition on use of force. So that is the fundamental underlying principle of the modern international legal order, which is that states are not permitted to resort to force against one another without approval of the Security Council, or unless they are subject to an armed attack and therefore have a right of self-defense. There had been, everyone I think kind of recognized that, but there had been a great deal of slippage. This was both the most outright challenge to that fundamental principle. Putin's invasion of Ukraine was in direct opposition to the prohibition on force and the prohibition on that goes along with it, which is prohibition on conquest of territory, both of which have been widely accepted principles of international law for hundreds of years before the modern era came into existence. But those principles now, the principle of prohibition on use of force and prohibition on conquest, are kind of fundamental to the modern international order. And Putin's challenge to those, I think there was a moment at which the question was, is that challenge going to basically lead to the collapse of the international legal order? Or is the world going to respond in a way that potentially revives it, or at least shows that it's still alive and kicking? And I think the response actually has been pretty remarkable. So we see the response with the General Assembly not very long after the invasion of Ukraine by Russia, decrying the invasion as an act of aggression, as Achilles rightly pointed out. And, we had 140 states that supported that resolution, including many states that have ongoing significant relations with both Russia and China. We only had 4 states vote with Russia, so only 5 states voted against, and they had about 40 states abstain. We just had another vote last week in the wake of Russia's claimed annexation or claimed recognition of these independent, quote unquote, independent territories of Ukraine. The support has only gone up. There was concern that there was sort of degrading support for Ukraine in the General Assembly. Quite the opposite happened. We had 143 states vote with Ukraine to condemn Russia's clear violation of Article 2.4 and of the prohibition on conquest. Again, only 4 other states voting with Russia, and this time 35 states abstaining. So we've had pretty robust response to Russia's attempts. And if you listen to the speeches, and I listened to a significant amount of the conversation in the Security Council first and then in the General Assembly, I couldn't have written those speeches better myself. They really spoke about like the fundamental importance of the prohibition on force. And again, Scott's in my book is all about the creation of that prohibition on force and where that comes from. And we argue that it originates with the Kelly-Briand Pact and then is reinforced in the Charter. But our central view is that that is the fundamental underlying principle of the international order. And delegate after delegate, representative after representative got up and basically said that. They were again and again sort of reaffirming the fundamental necessity of abiding by the prohibition on force and the fundamental importance of the international order's protection of states from resort to aggressive force by other states. Now, one might say, well, voting for a General Assembly resolution is an easy thing. What are states actually putting their money where their mouth is? And there are a number of ways in which they are, in which the General Assembly, we're both seeing a transformation of the General Assembly in response to the intransigence of the Security Council, and where this kind of unified voice of the General Assembly, I think, has enabled more concrete actions by states. So first thing to notice is both of these General Assembly resolutions that I mentioned, the first in March and the one last week, have been under the Uniting for Peace resolution, which had been sort of moribund, hadn't really been used for quite some time, which is a resolution that basically says that if the Security Council is basically stuck and there's a veto that's preventing the Security Council from acting, the matter might go to the General Assembly. There's not only were these resolutions both done under the Uniting for Peace resolution, But there's a veto initiative that was supported by a number of small states that essentially provides that automatically when a state vetoes an action in the Security Council, one of the P5 members vetoes an action in the Security Council, it automatically goes now to the General Assembly for consideration of that matter. And that this latest move there was an attempt to condemn Russia in the Security Council after the annexations were announced. That predictably failed because Russia, as everyone knew they would, vetoed it. And there was nobody who voted with Russia, by the way. There was a number of abstentions, but no one rejected the resolution. I think there was 10 in favor, 5 abstentions, and then Russia put in place its veto. And that procedure that has now been put in place led to it automatically going to the General Assembly, which I said had an even greater vote in support of the prohibition on use of force and against Russia's acts of aggression than it had in March, which I think was a really interesting answer to concerns that people had that maybe there was, there was kind of Ukraine fatigue and maybe sort of a declining interest in this among the countries of the world. I think what we saw was quite the opposite, and the effect of this new institutional structure that now is in place that potentially could routinize a kind of growth in the relevance of the General Assembly in moments like this, where the Security Council is rendered incapable of action by a veto of the Security Council. And so while I think it's not realistic to talk about kicking Russia out of the Security Council, I do think it's realistic to talk about shifting some power towards the General Assembly. And I think that's what we're sort of seeing in this latest set of events. And I think that's a good sign because, of course, every state has a vote in the General Assembly. There's much greater representativeness of countries around the world in the General Assembly. We all know the kind of problems with the Security Council in terms of who is represented and who is not represented. We don't have similar problems in the General Assembly. So overall, I think that has been a really important, both the kind of singular voice, almost unified voice on the prohibition of force, and the kind of revival of the General Assembly as an institution willing to act that I think has played an important role. That has in turn also, I think, enabled states to take actions that have really helped put some meat on the bones of these views. So the General Assembly's condemnation of Russia's aggression back in March, I think is part of the reason that so many states have felt comfortable joining sanctions, significant financial support for Ukraine, arming Ukraine, lethal force of kind of unprecedented kinds for Ukraine. I don't know that you would see states being willing to do that in the absence of a kind of clear message from the global community that what Russia is doing is clearly illegal and that Ukraine is defending itself and acting legally in its own self-defense under Article 51 and responding to an illegal act of aggression, and that states contributing to that are assisting a state in defending itself. So I think that while the General Assembly resolutions themselves have been merely symbolic, I think symbolism plays a really important role here because that symbolism allows states to support Ukraine and to convince their own electorate that what they're doing is, acting consistent with international law, that they are together with 140 some odd other states. It also, I think, has enabled companies to withdraw their support from Ukraine. Companies, in addition to states pulling out of Ukraine, companies have been pulling out. So I think this symbolic, merely symbolic move has actually had a really powerful effect. And I think, again, we're seeing this transition in kind of international institutions and a greater role for the General Assembly that I think has been really powerful. I'll just mention very briefly another phenomenon. So I wrote this article back in March called something like International Law Goes to War in Ukraine. It's in Foreign Affairs. You can Google it. If you're listening to this and want to read it, it talks through a number of ways in which international law, I think, has played an important role in the war in Ukraine. And of course, that was back in March. A lot has happened since then. But in addition to, the clear kind of reaffirmation of the prohibition on force and prohibition on conquest, the revival of the General Assembly, and the unity around sanctions and support for Ukraine in defending itself through unprecedented economic sanctions against Russia and economic support and lethal support for Ukraine, we've also seen all these international institutions that tend to be pretty sleepy kind of jump into gear. So the European Court of Human Rights has heard a number of cases against Russia. Of course, the Council of Europe kicked Russia out. And so the jurisdiction over Russian actions ceases as of the time when Russia was expelled. I think it was 6 months after the date on which it was expelled, but there's still jurisdiction over actions that took place before that date. So there's a number of kind of accountability efforts taking place through the European Court of Human Rights. The International Criminal Court has been remarkably revived by this moment. I think somewhere around 40 states supported moving forward with investigations. Ukraine, of course, is not a party to the International Criminal Court, to the Rome Statute, nor is Russia, but Ukraine had submitted to the jurisdiction of the court back in 2014 and then reaffirmed that and expanded it in 2015. That gives the ICC jurisdiction, and it's opened investigations. Karim Khan has got a number of investigations going on in Ukraine. And in the United States alone, which has had a kind of fraught relationship with the International Criminal Court, you had Republican senators getting up and like saying how wonderful the International Criminal Court is, and how much they supported investigations of war crimes in Ukraine, which is a remarkable turnaround for a party that had been sort of supporting sanctions against the court not that long ago. And so this has the potential to really play an important role in, I think, showing what the ICC can do and what role it can play in providing for international accountability and justice. Whether that's going to bear fruit, it's still to be seen, right? We're still early days. Investigation is underway. They're investigating war crimes, crimes against humanity, and genocide. The fourth crime, the crime of aggression, is not within the jurisdiction of the International Criminal Court, given the structure of the Rome Statute and the way that the structure over that one crime cannot be brought against the state, citizens of a state that's not party to the Rome Statute. There's a move afoot, which I have to say I've been supportive of, to have the General Assembly recommend the creation of a treaty between the United Nations and Ukraine to create a special court to try the crime of aggression. I'm very much supportive of this. If anyone's interested, there's a series we've put up online on Just Security that lays out the case for this and kind of what would it look like. And this would be an opportunity to actually bring a case for the crime of aggression, which has been sort of in theory in existence since the Nuremberg court, since the Nuremberg tribunals, but hasn't been prosecuted since then. And this would be an opportunity again to revive that as a principle, that the waging an illegal war of aggression is not only a violation of international law, but potentially could subject those responsible for it to personal criminal liability for those actions. And then we also have the International Court of Justice getting in on the act. Again, another sleepy institution that moved remarkably quickly in response to a submission from Ukraine asking for it to consider, very cleverly, they brought a case, Ukraine brought a case based on the fact that Russia, one of the justifications it offered for its illegal war was that they were claiming genocide being committed in parts of eastern Ukraine. And Ukraine very cleverly used that to gain jurisdiction in the International Court of Justice under the Genocide Convention to have that false claim adjudicated. The ICJ worked way more quickly than it ever has before. And basically in preliminary proceedings, ordered Russia to withdraw from Ukraine, determined that what it was saying was completely false, and ordered that the Russian troops withdraw. And so all of this is just a unified message from the international community of the kind we really haven't seen before. And so as an international lawyer, I actually see this both, again, as like one of the most remarkable sets of challenges to the core principles and core institutions of the international legal order, but also an opportunity for those institutions to rise to the challenge. And I see lots of signs that they're capable of, in fact, rising to that challenge. And I continue to hope that they will continue to do so as this war, unfortunately, drags on. So with that, I will turn it over to my fellow panelists.
Thank you very much, Professor Hathaway. Just a brief question comment. How ironic is that the revival of international law should depend on the authoritarian invasion of a country and the authoritarian initiative?
Yeah, I mean, it is ironic. I think the way in which often law, particularly international law, is seen is in the response to its violation. You know, so what we're seeing is what happens. We all kind of take these basic principles for granted to some degree. What happens when it's violated? And is there a robust response or not? And I think the robust response is the kind of answer to that challenge. But I think you're right. There is a kind of irony that it takes something like this for us to say, oh, actually states do believe in that prohibition on force after all. And oh, the prohibition on conquest really is a real thing. Now, you could have looked around the world and said, look, you know, as Scott and I did in our book, Scott Shapiro and I did in our book, look, interstate wars have fallen dramatically. I mean, just look empirically, there are many fewer interstate wars in the post-UN world. Conquest used to be incredibly common. It really doesn't happen anymore. And said, look, it looks like these institutions are pretty effective, even though lots of people say, like, you know, is the UN really doing anything? Does the UN Charter really matter? But it takes sometimes something like this, both to kind of wake people up and make them realize, oh, we've kind of been taking these things for granted. And actually, if states can just invade their less powerful neighbors willy-nilly, we're in serious trouble, right? So we're all in on this, because if this principle falls with Ukraine, then it's going to be Baltic states next, and then it's going to be the rest of Europe after that, and then nobody's safe. You know, and I think there's a kind of realization we all desperately depend on these principles to actually succeed. So I think that's part of what we're seeing, but it's also the case that kind of that's the way, unfortunately, international law works. You may not see it until it's violated and there is or isn't a response to it. And luckily, you know, we have seen a pretty robust response here. If we hadn't, I think we would all be writing the obituary for the modern legal order and be looking out for the collapse of the international system, which I think many people in the early days of the war were starting to do. And I think now things look a little bit better given the response that we've seen from many countries in reaction to what Russia has done.
Thank you very much, Professor Hathaway. Before Professor Skordas asks or puts forth his comment, and then Mr. Anderson, the baton is then going to be passed to Dr. Wagner for the rest of the discussion to be waged. So, Professor Skordas, please, we look forward to your comment.
Yes, I would like to ask Oona whether this optimistic scenario depends on Ukraine winning the war. And when I say winning, I mean that if we reach any compromise that gives Russia new territory, then the principles would have fallen.
Yeah, I mean, I think it probably does. And I think that's the real challenge, because there's an irony here, which is that I don't think that Ukraine can lawfully agree to any resolution of this conflict that entails giving up territory. I mean, I think that that would be, as long as there's any threat or use of force ongoing, any agreement to give up territory is both inconsistent with the principle of the prohibition on conquest and inconsistent with the principle that an agreement that is brought about through coercion or threat or use of force is invalid. And that is a conundrum because, you know, that means that Russia is going to have to lose, and Russia is pretty determined not to lose. And so the challenge, I think, is going to be the international community is held together since February. You know, what if this drags on for a year, 2 years, 3 years, 4 years, 5 years? You know, where are we going to be then? And I hope that the community holds together, but I think you're right to ask the question, you know, what is the end game? And I think the challenge here is it's very hard to see what that end game is going to be.
Solon, do you want me to hop in here, or Steven? Yeah.
Go ahead. Yeah.
Perfect. So I thought Oona's presentation was wonderful, and I agree with almost everything there. But I kind of want to cast a slight different light, because I think an interesting trajectory in some of these evolution. And Oona, I'd welcome your thoughts on this, response to this. I think this fits in well with your describing. But I think raises some questions about where we might be headed kind of after Ukraine, in that a kind of signature effect of this conflict actually is a delinking to some extent of international law enforcing action from the UN system and the Security Council in particular. Part of that is the shift to the General Assembly, but not entirely, right? You know, one of the notable phenomena we see in New Zealand, Chile, a few other countries, is actually the requirement to enact the new domestic legislation to be able to participate in the sanctions regime, because previously domestic legislation had been contingent upon Security Council approval. And even in the General Assembly context, you know, we don't know, I don't think exactly where that's going to go in terms of process, but it seems to me that it is much more of a permissive authorization. It is a lending of legitimacy to actions that are being pursued really on a bilateral, multilateral basis for many countries engaging in particular types of enforcing actions, right? So many countries can look at the General Assembly's condemnation of what's happening in Russia and say, well, this is a good reason why we are supporting the US and Europe-backed sanctions regimes, or export controls regimes, et cetera, to whatever extent. But that's not one-to-one by any means, right? Lots of countries sign on to the General Assembly resolution, but aren't willing to participate in a variety of economic measures. And nor are they obligated to do so. It's not UN Security Council resolution that would have that mandatory enforcement weight, however ineffectively enforced it has been in numerous cases, but nonetheless has that legal authority. And that's an interesting trajectory to me. I don't know if it's bad. I don't actually think it is. I'm not sure it's bad even for international law, but it does strongly, in my mind, imply a kind of, at least so long as UN Security Council is ineffective, and it seems likely to be at least around these big issues where there's a major global divide for a long time moving forward, it lends a different vision of how international law is going to be conceived of and operationalized in a way that strikes me lends itself perhaps to much more of a regionalization isn't quite right, to sort of a block mentality. You have groups of nations that have a particular view and are able to come to agreement on a set of enforcement measures. Other countries may kind of drift with them, agree with them ideologically, but aren't willing to take the same enforcement measures. And nothing really forces a one cohesive view or set of action, because there's no obligatory authority. And the General Assembly, again, I think has a kind of forum aspect. It's a way of communicating and endorsing legitimacy, but not compelling sorts of actions. This isn't wildly different than the way a lot of international law actions have been pursued for the last 30 or 40 years, and to different extents. But to my mind, it is a uniquely signature move towards it. And I'm curious what that's going to mean after Ukraine personally. Like, I kind of suspect this is because Russia and China and the United States are very openly now at loggerheads over the international system, and are likely to remain so, even if Russia becomes increasingly irrelevant, as I think is quite likely a possibility. That really poses a significant shift in at least how a lot of other countries have thought about enforcing international law in the post-World War II system. Again, I'm not sure it's a bad thing. I think you come out with better international law enforcement out of this. And the Ukraine is like kind of case one of that. But it is notable, and also depends on a lot of major states endorsing and backing up those views, which in certain cases may be more complicated than it is in Ukraine. And I would just say one thing, going back to the original point about UN Security Council reform or forcing Russia out, I would say also that strikes me as a particularly strange measure in this case, because I don't really know, in a case of outright aggression like this, would you actually get from additional, if you were able to act the UN Security Council? Because you already have collective self-defense as a legal framework from which to pursue almost everything we're pursuing, or a variety of economic measures that don't, at least arguably, aren't always linked to that sort of international law justification in the first place. And so this seems like not the case where you would see that, but it certainly has kicked off a conversation that may drive to some sort of shifting. But again, I suspect that's going to be, if anything, the erection of a separate, or maybe multiple separate, enforcement mechanisms for international law, and maybe a shift in focus to those away from the UN Security Council, as opposed to reforming the Security Council itself.
I might say just a very brief word about that. I mean, I think that a lot of that is true. I think one thing is to say, as you said yourself, Scott, that a lot of this has been a long time coming, and it's not entirely new, but maybe it's heightened in its form. I also will add that, again, while this is not an entirely new revelation, I think it's become more apparent that this kind of pursuing global free trade across the globe and sort of allowing oneself to be economically dependent on trade with one's adversaries is going to be viewed with a lot more caution going forward. And we're seeing that in the decoupling of energy, attempts to decouple energy markets, and the attempt to reduce access and reliance on microchips from China. And I think there are going to be two aspects that are going to come of that, is if this current decoupling kind of persists. One is going to be greater independence of states from economic trade with their adversaries. And that both makes it easier for states to engage in what Scott and I have called outcasting. So, forms of economic sanctions, including sort of kicking states out of organizations, but also kind of massive economic sanctions. I think outcasting has been harder for Europe, for instance, against Russia, precisely because they're so dependent on the economic markets are so dependent on natural gas coming from Russia. And so, they've been more cautious, and the US has had to be cautious in how much it pushes Europe, because it doesn't want to cause European economies to collapse. So, that's all been a vulnerability that has limited the capacity to some degree of Europe to kind of respond to Russian aggression. And I think there's a realization that we need to develop, energy independence, and we can't be so dependent on Russia. And that's both going to make us more capable of having that independence, and therefore to put in place economic sanctions against Russia as a tool of enforcing international law. But it's also going to mean that Russia is not particularly vulnerable to those sanctions, because it's going to have to find other markets for its energy. It's already beginning to find them. It has found them in China and elsewhere. So I think we're going to see, I think the economic transformation that we're seeing, that's being pushed by the rise of economic sanctions and the greater vulnerability that everyone is aware of, that global free trade brings in moments of these kinds of global instability and disagreements on policy matters that have nothing to do with the economics themselves, is going to have an effect. And exactly what impact that is it diluting the power of international law? Is it strengthening the power of international law? Is it kind of doing both at the same time? Because you're both, you have, if Western countries who are more likely to engage in enforcement actions are more careful about not having themselves fully dependent on the kinds of flows they're going to want to be able to turn off, that might be a good thing, but it also could be a bad thing, because as long as we're buying lots of stuff, then turning off those spigots, it makes a difference for those that we're buying it from. Whereas if we're not buying much stuff, then we don't have many spigots to turn off, so it doesn't have the same kind of impact. So I think we've got this whole international law conversation going on, but it's having this impact on the tools and techniques of enforcement of international law, which relies on the economy and the organization of the economy, and that I think is related to the matters you're talking about sort of these organized blocks, and exactly what direction that's going to be going. I think it's not entirely apparent, but it does seem like there's going to be kind of some of this decoupling and some consequences for international law enforcement as a result of that.
Dr. Wagner, if you can proceed with the discussion.
Great. This has been very interesting. Thank you. And by the way, for those of you that don't know me, I think I'm the only one here who's not a lawyer. I'm an historian by discipline. It's been very interesting. And the only comment I'd give before we move on to Scott's presentation is that I would observe that, first of all, Ukrainian policy toward the war has actually been, at least since it was clear that they were going to survive anyway, that completely aligned with the rules-based order that Oona described, that Professor Hathaway just described. And indeed, I have been, worried and wondering about how this is supposed to end if compromise becomes illegal. That said, these other changes that Mr. Anderson, Professor Hathaway, and Professor Skordas have been discussing, I think, have been creating new avenues. So it would seem to me we're entering a brave new world in some ways. I'd like to introduce now Mr. Scott Anderson. You all likely know him as a senior editor at Lawfare. He's a visiting fellow in the Brookings Institute, and he's here to talk about the United States keeping up its treaty obligations. So I will hand over to Scott.
Well, I will say this. I know we don't have that much time left on the panel, and this is a bit of a tangent from the conversation we've been having so far. Would it be useful to save the time to keep continuing this conversation as opposed to trying to
worry,
introduce
Mr. Anderson. You can continue as usual with your presentation. We can exceed the 1 hour. There is no limit on the hour. Please feel free to expand on your ideas.
As you wish. And I'm not sure it's such a tangent, by the way, given the upcoming election and America's, ability to supply Ukraine. And I'm not sure it's all that disconnected, but anyway,
Well, maybe I'll step back. I'll give a very high-level version and a relatively brief one, and try and tie it to some of these conversations along the lines you were just discussing. A key element, frankly, of developments over the past year, less than a year, that we've had in reacting to Ukraine and building up to the Ukraine conflict, in some ways more importantly, ties back to a lot of the United States policy. The Biden administration has been at the front edge of planning for, advancing, and trying to address Russia's aggression in this case. By no means unilaterally, actually been going, to their credit, to immense pains to underscore how closely they're working with European allies and allies in other parts of the world, but nonetheless a major actor there. And I think that necessarily raises a very challenging question, which is, would this have played out similarly at all if this had happened in 2020? Where you had a different administration that was much more skeptical of international institutions, much more skeptical of European allies, of Ukraine in particular, of Volodymyr Zelensky in Ukraine in particular, as we know from the impeachment proceedings going on at that time. It really begs a question to say, how durable is shift or change is this? And how much of it hinges on the particular views of national governments? And I will focus on, for my comments, the United States in particular. We are still in a moment where there is a substantial element of both political parties in the United States that are very skeptical of international engagements and commitments. It is a minority, I think, of both parties, a strong minority. There's overwhelming support from both parties of NATO, particularly in the context of this current conflict. A lot of people who have spoken very critically of NATO in the past have really stopped echoing a lot of those comments and shifted to be much more supportive, much more vocally, as well as other national institutions. Oona, I think, cited the most amazing one forever, which is Senator Lindsey Graham actually endorsing the International Criminal Court on the floor of the Senate as a means of investigating Russian crimes. I mean, you really have seen a dramatic shift. Who knows how long-lived that will actually be, right? I suspect there are ways you can capitalize on it, but it does require us to think about, how do you actually entrench and embed, or at least secure, U.S. participation in spite of these political trends, which again are still a minority element, but particularly in the Republican Party, very close to leadership. Former President Trump bought into a lot of these worldviews, particularly in regards to NATO and Europe. And therefore we can't ignore them, nor is the United States alone in this regard. Certainly many other states have these elements, and Russia has been well aware and to some extent cultivating a lot of these debates and discussions for the last 10 or 15 years, if not longer. Although I don't think you can discredit them by saying it's some sort of fabrication. These are genuinely held views by people on both sides of the political equation in the United States, at least. So in the United States, we particularly have a challenge in that the president runs U.S. foreign policy. It doesn't have to be that way necessarily, but that is the direction we have evolved in. The case study that I was planning on discussing, which I'm going to cut extremely short for the sake of time, and because it's a little bit of a tangent, is the North Atlantic Treaty, the foundational treaty of NATO, which we know former President Trump threatened to withdraw from multiple times. And frankly, looking at recent practice, strongly suggests that the president actually could unilaterally withdraw from it. The executive branch's current position, as far as we can tell, because they always have a lot of caveats when they articulate it, is essentially that the president has the authority to withdraw where authorized by Congress or where authorized essentially by international law, by the terms of the treaty or other international legal principles. So Vienna Convention law of treaties, material breach sort of situations, right? there have also been stronger views in the executive branch at times that may not have entirely gone away, that the president actually can just pretty much withdraw or terminate from a treaty anytime he wants to, because he's the voice of foreign affairs. This is a really troublesome, I think, exclusive arrangement when you're talking about an era where there are certain people, particularly close to the political leadership of at least one major party, have very isolationist views. That may be overstating it, but at least very critical views of certain types of international engagement. And the United States is at the same time playing a central role in some major developments in the international system and enforcing international law. And that raises new questions. First, in the election that's coming up later this year that Dr. Wagner's already mentioned, we already see Republicans in the House of Representatives, at least really not in the Senate, actually quite the opposite in the Senate but in the House, suggesting they may set more conditions and limits on assistance to Ukraine, kind of narrowing the outer limits of U.S. support, although no one has said that they intend to cut out support in the near term who's close to power there. So they're easy to overstate this, but it's certainly a real threat in the year to 2 year window, I think, of which the next Congress will be in place until the next elections. And then, of course, the 2024 presidential election, where we could see a return of former President Trump or of somebody who shares similarly skeptical views of the international system. In my mind, the thrust of the argument that I'm happy to go into more detail on, but I'll spare us for now, is that this is a moment where we actually need to see a strong reinforcement of U.S. commitment to the international system beyond strictly the executive branch. There are, specifically in the context of treaty withdrawal, which is the context in which I've written about this primarily, there are substantial arguments, I believe. I don't think we know exactly who has the authority to withdraw or to what extent it can be limited by Congress, but I think Congress could put up a fight and put up restrictions to prevent withdrawal from major foundational treaties that would put up a major obstacle for substantial disengagement by a president over the course of a single presidential term. Certainly a president could still limit the degree to which they're willing to participate in NATO, to abide by commitments under NATO, to engage in, collective self-defense if it came to that, but they wouldn't be able to interrupt the institutional ties that really integrate the United States policymaking apparatus with a lot of NATO allies on a variety of levels. There's a measure that's already being debated. It has strong bipartisan support. In the Senate, it was approved by the Senate Foreign Relations Committee in April, but was just removed from the NDAA, our big omnibus defense bill, I think in the last week or two. It's SJ Res 17, Joint Resolution 17 in the Senate. Similar measures have been introduced in the House in the past. So I don't think there is one actually being debated in the context of the NDAA this year. That would essentially try and establish it, put up a legal fight, have Congress endorsing and saying, you, Mr. President, shouldn't be withdrawing from this institution without our approval. And we're going to set up a legal argument and legal challenge to be able to oppose you if you try and do so. It's a very novel measure. It's not entirely unprecedented, but it's close to unprecedented. But I think this is a moment where there's good reasons why the Biden administration, Republicans and Democrats who support international engagement in Congress, and frankly, the international community should seriously be considering finding ways to support and encourage these sorts of measures as a way for the United States to double down on its commitment and underscore that even though we are in a presidentialist foreign policy apparatus where the president has a lot of authority, these sorts of core commitments will endure past a particular president. And I think it might mean that that individual, even foreign allies, might need to think about engaging a little differently. We have a real, I think, there's an understandable and often well-founded allergy to discussing domestic legal procedures that back up our international legal commitments. And there are good reasons countries avoid interfacing with them. But I think to a certain point, that sort of, deliberate veil of ignorance over what's happening behind these sorts of engagements, A, is a little bit of a fiction always, and B, it warrants a little bit more looking past it in particular key moments like this. And it might be a time where international allies should begin to think about, well, maybe we need to engage Congress, not just the presidency, but Congress, and really encourage Congress doubling down and reinforcing these key foreign policy pillars of the United States to reinforce them against potential movement away from that in future terms. I think that intersects with our conversation here, although again, a little bit of a tangent. I won't take us all the way down on the nitty-gritty details of this. But I do think we need to think about how essential is U.S. commitment in particular, and the commitment of other major powers to a lot of the trends we're talking about in the international system. If they are essential, then we need to set up the domestic engagement to reinforce them. Certainly in the United States, we no longer have political consensus that kind of ends at our borders around our foreign policy, as people more or less pretended that we used to have. We never really had it solidly, but we had a degree more consensus than we have now. And that's going to be the probably the reality moving forward. And so that requires a different sort of institutional response.
Dr. Wagner.
Yeah,
the
thank you very
yours.
much. Thank you very much, Mr. Anderson. It's been very interesting. I invite any comment from our other panelists.
Sure. I can ask, I mean, I agree with you completely, Scott. I mean, one of the sort of elephants in the room is the fact that the US has been such a key player in sort of rallying the world in its response to the Russian invasion of Ukraine, and has been supportive of, has been pushing these efforts in the Security Council, which then have moved to the General Assembly and has supported the General Assembly resolutions and has led the way in terms of providing extraordinary funding to the Ukrainians to defend themselves, and, had a full-throated and repeated defense of the international legal order and the sort of fundamental principles that are being opposed by Russia, and supporting Ukraine in those terms very explicitly. And the elephant in the room is like, what happens if the leadership changes? like what happens if, Trump or DeSantis or one of these like anti-international law people is back in the driver's seat again? And how fragile is this alliance? And I think the question you posed is a great one. The thing I struggle with, and I don't know if you have any answers to this, is like, is there anything that Congress really can do? So you and I think are both like advocates of Congress kind of getting back in the foreign policy game. Congress has kind of let itself effectively been sort of reduced to doing very little in the foreign policy space, except every once in a while getting excited about something and, making some trouble for the executive, but pretty rarely, every once in a while decides to do something usually not very helpful, like refusing to allow, Guantanamo prisoners to be brought to the United States, which makes it totally impossible to ever close a prison on Guantanamo. So Congress will do occasional things, but not usually very helpful things. So like whether we can expect Congress to do something, and if so, what we would want them to do. And I don't know if that's limited to something like, a piece of legislation saying the president can't withdraw from NATO without our permission. Like maybe that's one concrete thing that Congress could do. But then I don't know, even if you pass that legislation and say you've got Biden to sign off on it, you might. I don't know whether the Office of Legal Counsel for the next president is going to think that actually stops them from withdrawing. Like they might say, look, this is foreign policy, this is what we get to do. And, so I don't know how much I agree with you in the basic diagnosis of the problem. I just don't know what we can do to solve it. I don't know if you have any concrete thoughts about, what the foreign policy community in the US should do. And I don't know if there are analogs to this problem in other countries. I mean, we're seeing the rise of the right throughout Europe. And, that poses, this is not a problem sui generis to the United States. If you have the rise of these parties of the right, tend to be more sympathetic to Putin, particularly the Council of Europe requires unanimity on certain things. The EU requires unanimity on certain things. And what kinds of challenges does that pose to kind of holding together this alliance that has been so effective for this short period of time? But, how much is it going to hold? So that's a kind of putting the US problem into kind of a more comparative perspective. And, you only have like 4 minutes to answer like a giant question. Yeah.
It's really useful. I'll note what the few proposals that I outlined in the foreign affairs piece I mentioned, where Congress must protect America's treaties from 2020. So slightly outdated, but touches on a lot of this stuff. Constitutionally, when it comes to treaty withdrawal, I think that's one area where Congress actually arguably has more authority than we has seen it exercised recently. Historically, Congress has played a role in treaty withdrawal. It's really just faded off in the 20th century, and the president has been much more assertive about asserting his authority. attacked unilaterally, I should say. But we never really encountered a situation where Congress has expressly prohibited the president from moving forward with the withdrawal. The closest we actually came was the Open Skies Treaty, a treaty that President Trump withdrew from just in the last few years, and did so in the face of a congressional statute basically saying, you need to give us 40 days notice. The Trump administration disregarded that and said it was non-binding, and actually released shortly before Christmas, right before leaving office in December 2020, an Office of Legal Counsel opinion laying out the logic about why it thinks it has the exclusive authority to do this and Congress can't interfere with it. I think all Congress can do in the face of an executive branch that asserts the exclusive authority over this is to put it to the test of the courts and call the executive branch on its position. The executive branch is an advocacy body. Office of Legal Counsel is an advocacy body that lays out executive branch's views of its own authority. That doesn't mean they're right. What SJ Res 17 does, and I will admit, is based on an idea I published in 2018. I think that has been floating around Congress for a while, but keeps inching closer and closer to actual enactment. Would essentially set up a structure where you create a clear conflict with Congress and the executive branch, expressly prohibit withdrawal or termination, and then sets up the parameters that in the US legal system, I'll spare people here from going into too many of the details, where Congress could actually launch a legal challenge, or at least puts itself on the best footing, gives express authorities so as to avoid standing issues, setting up a direct conflict to avoid political question doctrine issues, and then also setting up linking any withdrawal to appropriations clause restrictions, so you have a double standing argument that is had more success in the DC circuit for potentially either the House or the Senate even being able to sue over it. It is, and then it pre-authorizes the House or the Senate legal counsel to enact on the basis of that legislation. So essentially, we'll say, Mr. President, if you move forward with this, we're going to fight it out in the courts. I think at a certain point, that's kind of what Congress actually has to do. That's all it can really do on its own. If you're going to have an executive branch that occasionally embraces these broad views. The other thing that could happen, the Biden administration could repeal that OLC opinion. I've suggested they do so on a couple of occasions. Institutionally, the executive branch is probably not inclined to do that in a particular area here. So I'd be a little surprised if they did. I think it'd be a good thing if they did, but it doesn't matter that much in the end because a future president could re-embrace those views later. So really only if Congress starts standing up for its equities, and that means fighting it out in the courts in the end, particularly in a case like this where you don't have the appropriation cycle to try and leverage and punish the executive branch in all cases, that's the sort of measure they want to do. And that's what SJ Res 17, if it were enacted, would try and do.
Thank you very much. Just before Professor Skordas also voices his stance, to remind once again the audience that you can put in the Q&A section your own questions here for the panelists. We have some minutes also here on board, and we look forward to receiving also your questions. And Professor Skordas, please. You have to unmute yourself, Professor Skordas.
Thank you very much. Two brief comments, one relating to the discussion on that Scott initiated on the domestic context, and the second brief comment on the international institutional system. With regard to Europe, we have slightly different problems, but at the end of the day, there are also problems that can block action. I'm not so much concerned about Madame Le Pen in France. She needs a couple of years until she tries again to get into the presidency. And I'm not also concerned about Italy because the government seems fairly moderate. Sweden as well. I'm more concerned about Germany because Germany has a very much deep pacifist mood, which makes every effort of bigger involvement on behalf of Ukraine difficult. And of course, we've contributed much to the war, but this has been done step by step with delay of months and months. And I don't know how far still Germany can go into this path. So in the absence of a United States leadership, I'm really concerned that the European front will tremble and will disintegrate, perhaps quicker than we think. My second point is about the United Nations system and decisions. Yes, General Assembly resolutions may not be binding, but we have a binding order of the International Court of Justice, which can legitimize practically many of the actions that we are taking. The order on the provisional measures, on the interim measures taken against Russia are binding. They're going beyond what one have expected. And I think the court is now the space where much will be discussed, because the ICJ made an extra step saying that my mission is not simply to resolve disputes, but to take measures for the maintenance of international peace and security. It's a unique statement of the court. And this shows that when one institution is losing power or authority, such as the Security Council, another one may try to fill the gap. And here is the cooperative action between the General Assembly and the International Court.
I'd like to just chime in quickly and agree with Professor Skordas on this, especially in our particular situation now, where we have so many Russian assets abroad frozen, and the court, and by the way, Ukrainian policy seeking damages. And the court is in a position to actually, I wouldn't understand the mechanism, how it would actually work, but Ukraine could end up being the owner of the Chelsea Football Club for all we know. I think this, in many ways, seems a lot smoother and more reparative, and even more punitive than waiting and depending on the Security Council or sitting on General Assembly resolution. We have a few questions coming in the Q&A, but before that, I'll just pass back to Scott.
Well, we can go to the Q&A. I was going to know on that particular point, I actually think this is an interesting example of another case where we're seeing a shift towards kind of decentralized enforcement, potentially, of international law. I mean, traditionally, you don't see a lot of clear automatic enforcement mechanisms, even for things like an ICJ donation of awards, right? It relies on kind of voluntary compliance. Maybe the Security Council could issue a resolution to enforce it. I'm not sure it actually ever has. Oona, you know better than I do, but I don't think the Security Council has ever done that. And so there's not actually great enforcement mechanisms for any sort of international law-based awards outside of like an arbitration context, maybe a select few other contexts. ICC also doesn't, my understanding is, doesn't give a ton of like financial awards in the ordinary course, although that may be because of the lack of these sorts of enforcement mechanisms. So if you're going to see, yet at the same time, we all recognize Ukraine's obviously the victim of violation of international law, and Russia should, under any sort of adjudicatory framework, be liable for substantial damages there. So if these assets are going to get transferred to Ukraine on the basis of the international law violations, which I think is the better basis, you're going to have to see countries shift how they think about enforcing international law to a much more decentralized model that has a lot of promise potentially in enforcing international law, but also has certain risks too, particularly if you're the United States or one of those handful of other countries that sometimes finds itself on the wrong side of international law, at least as it's viewed by much of the international community. So it's a very interesting evolutionary step, the one that I think we're likely to see a lot of debate about in the next year or so.
It's a very interesting comment. Thank you. I don't know if our panelists can see the Q&A. Or is it just us?
I think the opportunity is being awarded for the Q&A, so the questions to be seen. So maybe the answers can be provided directly. And the questions are from Dr. Lisa Mardikian, to say, from Brunel University London, and from Dr. Gerald Conway, also from Brunel University London. So the panel can address the questions directly.
Yeah, thank you. I would like to address the question first of Lisa Mardikian, and it's about the geoeconomic role and in this conflicts between China and the West. Here, if I would say that with one word, it seems that we are in a moment of a certain of the emergence of two globalizations. It is totally self-contradictory, the term, but the way China is looking to globalization is much different than what we are doing. For the Chinese, the state and China has a leading role to play in the evolution of global economy through the Belt and Road Initiative, through the steering and the political resolution of these conflicts. For the West, it's about free spaces, integration, and many more spontaneous actions. So we may be at a point in which we evolve towards two models. I don't know what the consequence would be. And with regard to the Crimean issues, under international law, there is no distinction. I mean, it's aggression there, it's aggression here. I mean, Russians may invoke self-determination or many other principles or strategic necessities, but they don't make any sense from the standpoint of international law.
Any other comments on that one?
I basically agree with all of that. I mean, on Crimea, I think, you know, the response was more muted of the global community to the annexation, the illegal annexation of Crimea in 2014. I think partially because it was kind of more of a surprise and it wasn't as brutal and bloody as the invasion has been. But as an international legal matter, it's functionally the same thing. I mean, it's an illegal seizure of territory that even then states noted was a clear violation of Article 2.4, and you know there was a whole host of sanctions, not as significant as the sanction had been since this 2022 invasion, but you know, as an international legal matter, they're the same. Politically, maybe they're not the same, you know, so the question is politically, although I think, you know, as we discussed earlier, I think it's going to be hard to agree to any illegal conquest in a final resolution of this. And particularly given that this war has been waged by both the West and by Ukraine and by other states that have been supportive of Ukraine, on the basis of kind of fundamental principles of the international order. And so it's very hard then to agree to resolution that's clearly in contradiction of those fundamental principles. And the Ukrainian government has signaled that it does not intend to compromise. So, you know, there doesn't seem to be a whole lot of room for that kind of solution. So the downside of that is it means that this might drag on longer. And because it's hard to imagine Russia, as badly as it's waged this war, it's hard to imagine it ever fully giving up, particularly given that it's able to throw a lot of recruits from, we haven't mentioned this yet, but I think it's worth mentioning, a lot of the conscripts are coming from poor regions of Russia, ethnic minorities, you know, people from communities that are extraordinarily disempowered within their own community. And in a way, there's kind of a convenient internal genocide going on here through sending these very unprepared conscripts to the front of Ukraine. So, the thing that keeps me up at night about this conflict is that it's hard to imagine what the end actually is going to be, given all of that.
I would just add on to that as well. There's also a unique Putin calculus as the reason why this is so ineffective, right? Like part of the reason people under-responded in 2014, because I think there was an idea that Putin may generally stop there and cause mischief in the rest of Eastern Ukraine, but it wasn't worth the kind of dramatic response that we're seeing now. That's obviously proven false. And now we've seen, you know, Putin say, well, or strongly signal at least, you know, maybe I'm satisfied with just Luhansk and Donetsk and I'll stop there and not worry about Kiev like I was originally trying to do. And no, he's buying it. And it's because he's got a credibility problem, because he has now multiple times suggested, oh, I'll stop at this line, and then push past it just a few years later at the next opportunity. That's going to make it really difficult. Now, if there were different Russian leadership, would there be a political argument about Crimea? Maybe. I don't personally know enough about like Russian identity and politics and how it fits in there. I could see that being a possibility, but it doesn't get you around the international argument that Oona's already argued. I think all you could really do in that case is to say, maybe you agree to a ceasefire or to some sort of acknowledgement of the de facto conditions, not acknowledging their legality, and then maybe 50 years from now, if the status quo settles in and there genuinely is no threat of coercion, and Ukraine says, okay, we're not actually being forced into this, we actually are willing to accept this, our borders have changed, that kind of cures the initial unlawfulness potentially. But that's a decades-long kind of like cultural change, not something you negotiate. So there isn't an easy way out, although I think that's the only path you get to negotiate a solution, is acknowledgement of de facto conditions, not commenting on legality, and then hoping maybe other factors drive the two parties to peace long enough that you can actually have a more effective permanent political resolution.
In this point, just to know that we're going to wrap up the event also in 2-3 minutes. We have another question we're going to answer now, but to thank you in advance for your participation of the panelists, all the people in the audience. The next BUL International Law Group event is going to be in November, so stay tuned with our YouTube channel where the video is going to be uploaded, and also the announcements in Facebook and elsewhere. And here, Dr. Wagner, the last question for the panelists, and we close the event. And thank you again.
Well, thank you. Actually, the question I had come prepared with was about the end of the conflict. So we've discussed it, I think, at length. It's just as depressing as I thought. The only other thing I'd add is it strikes me as like the most awful irony of the whole thing is that all Russia had to do to get what it wanted in Crimea was to hold a secession referendum according to the Ukrainian constitution. And I think that would have been a lot more likely to succeed in around 2014 than it will now, if that was even, ever going to come back to the table. But if, another nugget I took away from Professor Hathaway and Professor Shapiro's book was that, this mechanism of secession by plebiscite, it seems another important part of the international order that has been completely corrupted these days. If you have any final comment, I'd be very happy to hear it.
Yeah, I mean, I think just very quickly on that last point, I think Putin has sort of tried to make it look like this is sort of like coming from the people, and he did that in Crimea, and he's done that through these elections, these referenda in these independent regions, and nobody's buying it because there's such clearly rigged elections. You have armed people coming around with ballots and telling people basically how to vote. So it's very clear but I also think it's actually one issue on which the international community is pretty unified, because almost every state has a region that, if succession suddenly was something that regions could do if they chose, they would secede. And I think this is one reason that China has sort of been holding Russia's a little bit of arm's length, because it doesn't necessarily, although it's abstained from, it's not voted with Russia, it's not voted against it, it's abstained from both of the General Assembly resolutions, but it's abstained rather than voting with Russia, and sort of held Russia at a little bit of arm's length, because last thing China wants to do is open up a door to regions taking the votes and deciding that they can legally secede from a country, and that's enforceable, and that the rest of the world has to acknowledge it. So I think Russia has got a real challenge to face there, and both as a matter of international law and as a matter of just global politics. And thank you for this conversation. It's been great.
Thank you, and thank you to all of our panelists for joining us. And back to Solon to wrap up.
And indeed, we greet everybody. We bid everybody a nice evening to everybody. And we look forward to seeing you in the next BUL International Law Group events. Thank you very much. Have a nice evening.